The moderator for this panel is Dr. Zhang Enren. Dr. Zhang is the Deputy Director ADR in Arbitration, ICC's North Asia, Shanghai, China. The first speaker for this panel is Mr. Mia Shiraz Javed. He is the Barrister number 5, Barristers Chambers, London, United Kingdom. I would invite Mr. Amar Bilal Sufi, our next speaker. Partner Amar Bilal Sufi & Co. Lahore. Our next speaker is Mr. Yuhong Wu, Managing Partner, Deheng Law Firm, Vice President Chengdu Lawyers Association, Shanghai, China. I would now invite Ms. Minaz Malik, Barrister 20 Essex Chambers, London, United Kingdom. And our last speaker is Mr. Justice Muhammad Abdul Rahman, Honorable Judge, Sindh High Court, Karachi, Pakistan. I would now request Dr. Zhang Enren to start the panel discussion.
So the second panel of the day, actually the panel is entitled Resolving Disputes Involving State and State Entities under ICC Arbitration. So we will discover the fairness, efficiency, and the transparency in international dispute resolution, international arbitration, with a focus on ICC arbitrations. So although our MC has already introduced our distinguished panelists, but please allow me to briefly introduce you again. So first of all, my name is Zhang Anran. So I'm the Deputy Director of ICC Arbitration at ADR, the ICC Dispute Resolution Services in North Asia. So on behalf of ICC, I would like to thank the organizers for the kind invitation and the wonderful arrangement for everyone. Thank you so much. So ICC, as the world's most preferred institution, we are providing the dispute resolution and provision services, and we see a dramatic growth of the disputes involving Pakistan parties. So in the past 10 and 5 years, respectively. So we also see cases that is seated in the city of Pakistan. So why we choose this topic to share? Because within the ICC experience, about 25% of our cases are involving state and state entities. So I think it is no better institution than ICC to talk about the state and the state dispute entities dispute resolution. So my distinguished panelist from my left hand is Mr. Mia Shiraz Javed. So he is a civil engineer turned English barrister at number 5 Barrister Chambers. So with a specialization in construction and energy law, acting as an arbitrator, mediator, and judicator, etc. So Shiraz is also the founding chair of Charter Institute of Arbitrators, Pakistan branch, and also the TCC ADR Center. So now please allow me to introduce Mr. Mabari Sufi. So apologize again if any pronunciation for me is not correct. I will try to do better next time when I return here. So Mr. Sufi is an advocate of the Supreme Court of Pakistan and is also the managing partner of the ABS and Co. He is also the ICC court member representing Pakistan within the ICC Court of Arbitration. And before he served as the Federal Minister for Law, Justice, and Parliamentary Affairs, he also served as the chairman of the Advisory Council within the United Nations Human Rights Commission in Geneva. So then we have Mr. Wu Yuhong. So Dr. Wu is the senior partner at the Chengdu office of Deheng Law Firm offices. And his practice includes the cross-border investment, corporate compliance, inter-IP, dispute resolutions, and actually before practicing law, Dr. Wu is also a real doctor in the real life and also an IT professional for many years. So next will be the Ms. Minaz Malik. And Ms. Malik practiced as an arbitrator and barrister from 20 Essex Chambers in London. So she has over 23 years of legal experience in trade and investment, including serving as an arbitrator as a counsel in commercial and investment law matters. So last but not least, it's our honor to have Mr. Justice Muhammad Abdul Rahman, who is a judge at the High Court of Sydney. He was called to the bar from the Interchambers Temple in 2000 and began practicing law in 2001, and was involved as an advocate of Supreme Court of Pakistan in 2016. So during his period of practice, he also regularly teach in London. So welcome, and so let's start with our conversation. So I understand that we have about 1 hour and 10 minutes, so roughly now it's 1 hour and 5 minutes. So hopefully you will enjoy our panel discussions rather than in this format. So first part, I would think to invite the speakers to to outline the landscape of the Pakistan-related projects involving state and state entities. So, Mr. Sufi, so could you share a really brief overview of the projects and the investment that made in Pakistan, those involving state or state entities? Thank you.
Thank you very much, Zhang. Bismillahirrahmanirrahim. Khawateen wa Hazrat, Assalamu alaikum. Honorable judges of the Supreme Court, honorable judges of the High Court, honorable judges of Sindh High Court and other high courts, Assalamu alaikum. It is a matter of great honor to be here in this panel and to represent ICC work here and see where it takes forward Pakistan in terms of the manner in which the arbitrations are to be handled by the ICC framework. But before I do that, I think it is in order that I briefly talk about the vehicle that drives the country's economy forward. That vehicle has 4 wheels. The first wheel is that of political stability. The second wheel is that of sanctity of contracts. If we uphold the sanctity of contracts, disputes will be minimized. The third wheel will be or is the foreign direct investment and local direct investment, FDI and also LDI. And the fourth wheel of that vehicle is a mechanism that creates mediation, arbitration, and judicial apparatus. The subject that we are discussing today are the remaining 3 wheels. The first being the significance of sanctity of contracts. It is extremely important that as a country, as people, as a state, we uphold what we agree, what we sign, what we execute. And if we uphold that in good faith, then the mechanisms relating to dispute resolution, the stress on those mechanisms will be minimized. For the disputes to arise, people have to rethink, people revisit what they have committed. And if there is a good faith, and the good faith is also joined by genuine faith towards associated with the sanctity of contracts, then the dispute chances stand minimized. International Chamber of Commerce, or ICC, focus is initially on its work relating to upholding contracts and also to minimize confusions relating to complex contracts. So you have ICC work on Incoterms that facilitate and divide and define in a standard manner the terms that create confusion, the terms that create disputes. Likewise, when we are talking of the CPAC, China, Belt Road Initiative, movement of goods, then TIR Carnet legal framework by ICC in a standard mode is yet another helping tool. And then we have, when disputes, then the ICC arbitration rules come to rescue in terms of what they provide, in terms of the detailed, extensive mechanism that they offer. And in addition to that, there are ICC mediation rules. These rules provide an opportunity to even make an effort not let go matters even to arbitration, let alone litigation. I remember Justice Mansoor Ali Shah's speech some days ago in Islamabad, in which he argued that given the stress and the burden on the entire judicial system, effort must be made to alternatively settle dispute, to find means, mechanisms. And that's where the work of the ICC relating to mediation rules could be of great support, and it makes available an additional tool to look at, to examine if it could be applied or made use of in domestic dispute frameworks. I would also like to mention that the ICC is normally the preferred venue where parties agree to arbitrate for the reason that ICC perhaps has the most comprehensive secretarial support than any other institution in the world. So not only you have judges picked up from various jurisdictions, the support that ICC Secretariat provides is amazing. The mechanism of review of awards, draft awards, internally done, is perhaps one of the most comprehensive mechanisms.
Thank you. Thank you.
Pakistan, sorry, you
No,
want?
no, no worries. So I think we will touch upon to the ICC specifically, but just quickly, like how the projects and investment involved.
I was coming to that.
Yes.
So the preference for Pakistani government and also the preference for Pakistani entrepreneurs is to opt for the ICC as a venue of arbitration. Now that preference is sometimes driven by various motivations.
Yeah.
And as I said, one motivation is when they get to appreciate that this has a very comprehensive mechanism, objective, transparent, and so on. So we have the federal government which enters into agreement. We have ICSID arbitration treaty frameworks, but then we have about 280 statutory bodies which are slightly outside the federal government who interface with international investors, and those investments provisions are again providing for the ICC as a venue.
Yeah, thank you, Mr. Sophie. I think it's, you point out that within the project and investment involving state and state entities in Pakistan, that in the dispute clause sessions, ICC is one of the choices, and we preferred choices, and it's really important. And please allow me to recall the first panel, which is focused on the CPEC. So maybe we invite our panelist, Mr. Wu, to any experience regarding the mega projects involving the state and state entities in Pakistan. So especially those from the Chinese SOEs, and also I assume that you have many clients that have the projects here in Pakistan.
Yes, thank you, and thanks PIDC invite me to participate this event. It's quite, an honor to be here. It's a pleasure to share, exchange, and learn from our colleagues. And I think this is extremely important when our world is really in a difficult time. So today I'm going to talk about the experience of mega project, of Chinese state enterprise, and actually Chinese business. According to news report, China has invested 25.4 billion in Pakistan over the past decade. Under the Belt and Road Initiative, particularly China-Pakistan Economic Corridor, CPEC, Chinese business have invested and participated in projects in almost all sectors of economic activities in Pakistan. Project like energy project covering coal-fired power plants, hydropower plants, solar park, wind farms, transportation projects including roads, railway, airport, seaports. And many of these projects are mega projects, given the scale of the project, the amount of the investment, and then their impact on economy and society. For example, the Guadar project aims to replicate the success of Shenzhen to transform a fisher village into a modern, smart port city, acting as a hub of trade and investment in the region. The success of Guadar project will not only bring huge economic return to investors, but also bring prosperity to the region and upgrade the regional economic landscape. However, mega projects are complicated, difficult, and prone to dispute. First, mega project takes a long time to complete and operate. It is not unusual that the duration of a mega project can last over dozens of years. The long life cycle of mega project means that project will certainly be subject to more uncertainties, which could be local, regional, and global economic contingencies, natural disasters, geopolitical events like terrorist attack. The list can go on and on. Second, mega projects are made of complex processes that involve numerous and diversified participants and stakeholders whose goals, interests, and agenda are not perfect aligned and sometimes in conflict. This means that disputes in mega projects are inevitable. Moreover, cross-cultural communication and language barrier cause misunderstanding and miscommunication that might appear to be minor issues at the beginning, but often and almost always, if without preventive and early intervention measures, will escalate into fully fledged dispute. So it is worth to notice that the stakeholder of many of those mega projects include state and state entities, which have often been direct participants and parties to legal agreements implementing the project. Taking electricity project, for example, state and state entity are parties to implementation agreements, power purchase agreements, certified emission reduction agreement, and water use agreement. So, according to the Pakistan construction dispute report, 95% of construction projects in Pakistan had one or more disputes. Although I don't find official statistic data on disputes in CPAC mega projects, but our experience in serving mega projects show that disputes are plenty. Dispute could be on overrun in project time and cost, differing site conditions, lack of funds, unclear risk allocation, loss of profit, and other contractual claims. Like indicated in many research and reports, dispute over payment delay is prevalent in many projects, including CPAC mega projects. But anyway, resolving dispute involving state and state entity is not easy. And resolving the dispute with state and state entity in fair, efficient, and transparent way is more challenging. But it is encouraging to see legal professionals around the world is taking this challenge. So I'm going to stand back.
Thank you, Mr. Wu, and it's a good timing control. So I think you mentioned the point that for the legal practitioners, it's really it's still like a challenging somehow. But within the within the arbitration framework, I think one of the key factors that both the parties to negotiate contract as well as the parties to the dispute will consider is the enforcement of the arbitral award, as well as how the local court can play an incredible role in the arbitrations. So may I invite Justice Raman to give a really general introduction on the role of the court to arbitration in the legal system of Pakistan. So what also, like, is there any links between the government approach and also the court approach towards the arbitration in this country?
Thank you for that. May I begin by just stating that these opinions that I have are mine personally, and I don't intend to advocate for either the Sindh High Court or for any other member of the judiciary when I make these statements. I've been a judge for just about a year. Prior to that, I was a practicing lawyer. And my understanding of an approach and perspective of how the system absorbs arbitration is not too good, I must admit. Let's just look at it in perspective of what Mr. Emir Bilal Sufi said, and I can't agree with him more. The purpose of a court should be to enforce a contract. That is potentially the most important thing that a court can do in terms of contractual obligations. The system that we currently have and our procedure doesn't encourage that. What it does instead is permits a person to enter into a court and delay the process for the enforcement of an obligation. And it does that both in terms of contracts, and it does that both in terms of arbitration awards. On a very practical note, when I was sitting on the original side of the High Court of Sindh, when it came to enforcement of arbitration awards and our cause lists, they are literally last on the list. So after a day of 50 cases, they come up right at the end when there's very little time to actually hear the case for that enforcement. And this is just one aspect of how we can just change that to bring it to the front to allow for the enforcement of such awards. The other aspect that I've found quite often is that an arbitration proceeding has started, and instead of allowing that arbitration proceeding to proceed, we find ourselves with multiple litigations which are attempting to frustrate that process. And that is potentially one of the biggest distractors from the enforcement of arbitration awards, which really, really needs to be procedurally addressed in our systems. Added to that, and I know Mr. Mia Hassan Gul Aurangzeb is here, we have also multiple jurisdictions. So we have not only the original civil jurisdiction, we have the constitutional jurisdiction. And you will often find that constitutional petitions are filed to invoke that jurisdiction, again to frustrate arbitration proceedings. And I refer to Mia Hassan Gul Aurangzeb because he advocated twice and he threw those cases out. But that process took time. So when we choose an arbitration process, are we able to turn around and guarantee that that arbitration process will be the only process that is followed and which then comes into our legal system for enforcement and which is then enforced expeditiously? And to be able to achieve that, you need to turn around and bring clarity to the use of those other jurisdictions to bypass the arbitration process, which currently I think has not particularly been done. I mean, take for example the Honorable the Supreme Court of Pakistan. It has an original jurisdiction, and it can turn around and invoke that jurisdiction to bypass an entire arbitration proceeding. So there are multiple forums that can be used to turn around and get away from just allowing that arbitration process to continue. And unfortunately, we need to bring clarity either in the law, in our procedure, to say, look, if you have an arbitration, do that, come for enforcement. I think it was earlier stated that the two grounds would be jurisdiction and natural justice. And I think that's good enough.
Yeah, thank you, Justice. I think we will come back specifically on the enforcement. Thank you. So issues later. So now I think we have the general pictures about the projects, the clauses, and also the court perspectives. So let us turn back to focus on two specific procedures of arbitrations, or two types of arbitrations. So let me first invite Ms. Malik to share some observations about Pakistan-related disputes in international arbitrations, especially those involving the state as parties. So any major characters and any practical experience that you would like to share with us? Ms. Malik.
Thank you so much. Assalamu alaikum. It's absolutely lovely to be here. In cricketing terms, it's my hat trick. I was at the first, second, and third editions of the Pakistan Disputes Week, and I'm delighted to be here again. I also wanted to thank the organizers for inviting me, but also perhaps to borrow from Lord Hewitt's famous dictum that justice must not only be done, but also must be seen to be done. And I'm afraid I'm going to stretch that a bit by saying it's so delightful to see so many judges here from all the courts in Pakistan. It's lovely to see justice here at this conference. It's very, very reassuring. So before I launch on to the topic, I also have a disclaimer, and perhaps I can't put it as elegantly as my co-panelist judge has done. In addition to serving as an arbitrator and as a barrister at 20 Essex, I have also taken on a new role where I'm an external judge of the World Bank Sanctions Board, which means that whatever I say today does not reflect on the title I hold at the World Bank, and I am speaking as an independent practitioner. So with that, I shall get to the very interesting topic that our chair has raised for me. Now, ICC arbitration has been around, but in a sense, international arbitration has many, many different institutions and has had an interesting history in Pakistan. I think some of us are old enough in the room to remember the famous Hubco case of the 1990s and how arbitration has evolved over the last few decades, not just in Pakistan, but across the world. And every time I speak to newer practitioners now, it's very hard for them to understand that there was a time when courts were very concerned and perhaps even a little jealous about international arbitration. Those days are long gone, and as my co-panelist said, it really is key to enforce the bargain that the parties have agreed to, provided it is a valid bargain. And that's incredibly important for not just international arbitration, but rule of law, and as my other co-panelist, Mr. Sufi, said, for trade and investment, because that's the key pillar that drives investment and trade, particularly when it crosses borders. I work in so many jurisdictions and so many courts, and often people ask me, which court, which jurisdiction? And I always say, depends whose court you're in. You always have jurisdiction over your own court, and that's where you reign supreme. But we shouldn't forget that those parties, especially if they have cross-border trade and investment, will also have other courts. And it's so important to be mindful of other jurisdictions in making your decisions. And this is where I come then wholeheartedly to the question that the chair has raised for me. How has Pakistan fared? What do we mean by state entities and states' experiences with international arbitration? Pakistan signed the ICC Convention very early on. It has been quite open to signing a number of bilateral investment treaties. In the 80s and 90s, state entities and the state itself was quite happy with agreeing to international arbitration clauses, be it ICC, be it ICSID, even LCIA. So the state has been quite open. And in fact, I would say in the early years, very open also to foreign law. So bear in mind that the arbitration clause has different pieces to it. As a mechanism, you have the governing law of the contract, which can be separate from the law of the arbitration clause. And often the compromise that states make is we will have our national law, but we're happy to agree a foreign law of arbitration by, for example, designating a foreign seat. So the compromise you found was Pakistani law is the governing law of the contract, but the seat could be ICC London or ICC Paris or just LCIA. With ICSID, of course, it's a bit more complicated because in reality, ICSID is a self-contained system. So what you see in Pakistani sort of contracts is you either see Pakistan as the governing law and you see a foreign seat, or you also see what has become, I think, more increasingly common is you see both the seat being in Pakistan, but with an ICC Pakistan sort of provision, but the law is also Pakistan. Those contracts mean that the government has bargaining or negotiating power, typically when it's hiring someone. It's slightly different when you're trading as equal parties and you're trying to find a compromise law. So that is where the compromise typically happens in favor of a law. English law, since it's my jurisdiction, is often a compromise law, which keeps us busy. The problem is when you're dealing with a civil law jurisdiction like China, and I'm here encroaching on my co-panelist's sort of domain, to find that compromise. I think, just to wrap up the question you put to me, it's very important for states to understand the arbitration provision and the obligations it imposes. I recently represented a Central Asian state against a government contractor, another civil law country. Both were civil law countries. And it amazed me that the contract was governed by English law, the seat was London, it was an LCI arbitration, and civil law was completely at odds with the state entity's own constitution. I mean, the civil law was there, but it was completely at odds with the English law that was governing it. And it came as a real rude shock to them to find out that they'd breached everything. So the message I really have here is, please, when you enter into arbitration agreements, that is the time to understand the obligations you're taking on and to ensure that you're not in breach, so no surprises come in the arbitration proceedings later on. So I hope that answers your question somewhat, but I'm happy to
I would say it's more
continue
than
commenting.
answer to my questions. It's much like a really expensive and valuable advices from you. I think also to our participants. So now I think let's turn to specific contract perspectives. Like I assume that CPAC contract is something that is one of the hot topics for our conference and event in these 2 days. So Mr. Shariz, so you are also happy to share with me that you are now part of our national committee, ICC Pakistan task force on the CPAC. So could you to share with us that any framework of that CPAC contract in Pakistan, that what kind of disputes that they are being applied, and is there any model for the CPAC contracts?
Thank you, Ryan. I think Menaz very rightfully touched upon a couple of things. It's the time of the signing of the contract when we have to be mindful about the dispute resolution process. And in construction industry, we say these contracts are meant to be kept in the drawer, and they are taken out from the drawer at the time of the dispute when the need of the lawyers arises that we need to do something about it. And then the client or the contractor, they realize what sort of dispute resolution mechanism or the dispute resolution agreement they have entered upon. For example, in Pakistan, there are a couple of segments or a couple of mechanisms that are going on. If we talk about the power sector, most of the power sector, they have got LCIA to be their dispute resolution forum. So most of our power cases, they go to London for dispute resolution. And then we are also a signatory to ICSID. We are very famous in losing ICSID cases. And while this was going on, we entered into the China-Pakistan Economic Corridor Agreement somewhere in 2013. And so we need to understand what sort of contracts has been signed between the two countries. Like the investment started from an initial investment of 46 billion US dollars. So most of these projects, they are either construction infrastructure or from the power sector. And primarily, FIDIC Red Book and FIDIC Silver Book, they have been adopted to be the standard form of contract for all these contracts. So the investment, which was initially $46 billion, is expected to surpass the monumental landmark of 100 billion US dollars. So this is something huge, and we need to first understand what the standard form of contract they are using. FIDIC is the most popular standard form of contract for construction and EPC contracts around the world. You don't have much space to change the general conditions of the contract. But yes, you have the option and the authority to change the dispute resolution clause. Since ICC and FIDIC goes hand in hand, so we see most of the FIDIC contracts, they give mention of ICC to be their dispute resolution forum. I've seen a few of the contracts. They have mentioned SCIA to be the dispute resolution method to the forum. But most of the contracts which are being executed in Pakistan at the moment, whether it be Dasu Dam, we have seen a number of projects that has been quoted since morning, specifically for China-Pakistan Economic Corridor. They have ICC being the dispute resolution forum for if a dispute has been crystallized. So this is where the ICC comes in. I don't know whether both the parties, they were mindful of having ICC to be the dispute resolution forum, whether they understand once the dispute will arise, what exactly is going to happen. Whether are you going to invoke ICC Paris? Is it going to be ICC Abu Dhabi? Or is it going to be ICC Hong Kong? And in whatever circumstance, in whatever the case may be, how things will initiate. So these are the basic things which we need to know at the time of signing of those contracts, which I believe as part of the task force for ICC, we will be taking on this matter, and we will educate and we'll try to provide the awareness to the relevant quarters, especially to the construction sector in Pakistan.
Thank you. Thank you, Sharis. I think you point out really key issues that focus on the ICC arbitrations. And then let's just focus on the ICC arbitration from now on. So I think you mentioned that the seat of arbitration also, I believe that our distinguished other panelists also mentioned the seat of arbitration. Actually, within the ICC arbitrations, it was seated actually each year in more than 100 and around 120 jurisdictions. So it was seated in Pakistan as well. So it is not only that our headquarters is in Paris, it has to be seated in Paris. It is seated everywhere. I think that is really something that we can, I would say, is important factors. And added to that, there will be that the enforcement, the quality of the ICC award. So may I invite Justice to share more about the ICC awards, like how the current situations works for especially the ICC arbitration award to be enforced in Pakistan. So is there any potential systematic challenges or ongoing changes that is going on in Pakistan that ICC can also may help with in this process?
Well, I don't think that there are any real issues with ICC. The problems that we have in terms of enforcement of any award is really one of time. That's probably the biggest issue, and that's a systemic issue that exists in the legal system, which can be addressed. After the New York Convention was ratified in 2011, we took some time to develop the paradigms on the basis of which such awards would be enforced. But with the recent judgment of Justice Mansoor Ali Shah, I think that is now more or less settled. So it really does not require much dispute now as to the manner in which those awards will be enforced. The problems, as I earlier advanced, were really in terms of the time period to get it in there. And that is something that can be easily addressed by turning around and by doing a bit of case management on those. If you just do a bit of case management, those can get some priority, they can be enforced. And the other issue, of course, as I earlier mentioned, was in terms of the multiple jurisdiction issues. In terms of the New York Convention, and now with the Arbitration Act of 2024, which is being processed right now through Parliament, I do believe that will really cut down a lot on the bottlenecks that existed in terms of enforcement of such awards.
Thank you, Justice. I think also within the ICC structure, I think one of the factors that the enforcement of the ICC award is never be an issue is because we have really internal case management process. So one of the key issues, one of the key function is through the ICC Court of Arbitration, which is constituted with one president and 196 court members across the world. So all these members will regularly meet every week, not every day, but every week, to meet with the cases to scrutinize the draft arbitration award. So may I invite Mr. Sophie to share your insight about the ICC scrutinized award, which can ensure the enforceability of the arbitral award of ICC.
Thank you very much. Basically, as I mentioned, there's a very extensive procedure within the ICC to evaluate the awards once they have been prepared by the arbitrators. And the Secretariat normally raises a committee or a group of from amongst the judges, and then one secretarial person is designated to examine the award in detail and provide a very detailed briefing to the entire group, which has been done virtually in the last 2-3 years, but mostly now it is coming back where personally they are sitting at various places of choices, and then a detailed agenda of 6, 7, 8 awards is being examined. It takes about quite a few hours to go through the concerns that has been raised by the Secretariat and the discussion that takes place between the court members. And finally, if there are certain recommendations for changes that needs to be made in terms of costs, in terms of corrections, in terms of any issue relating to the sequence of the legal argument, they're referred back to the arbitrator. But other than that, most of the awards are then scrutinized. So in that sense, the quality surely is quite credible.
So what is when you attend the court sessions, what is the key issue that you will first look into to ensure that the arbitral award is enforceable?
Well, obviously, arbitration award, once it's obtained, it will need to be implemented in the host country. And if the host country is Pakistan, then we always have issues, some have been pointed out earlier. But now I think there has been a much more improved ecosystem for the enforcement. There's a pro-enforcement approach. And even if you have an award, still there is a suggestion for mediating that award implementation steps as well. And I can tell you from experience that now the batch of young judges that we have in various high courts, their understanding of this entire arbitration landscape is far better. They are well connected, they are well wired, they are following up developments. And I think it is that nucleus which is creating a new wave of awareness within the judicial process. And we clearly see an attitude where the judges are inclined to enforce it more readily. But at the same time, as I said, since the enforcement also takes a while in Pakistan, or for that matter in any country, so judges also sometimes suggest to mediate the process of enforcement as well. And that is also working, and in certain awards we actually saw that the negotiations relating to enforcement were also a success. So the role of the judges is becoming very crucial, and their inclination, they have, for example, identified Federal Judicial Academy as a venue. And and I was recommending to some that if they could engage some sociologist who could identify and persuade people from a cultural standpoint, that if it is good cultural sense, you may actually have lesser disputes.
Thank you. I think it's very valuable from the inside as a court member. So also like now I would like to offering one like opportunities to the participants who are in-house counsel. Actually, if you are in-house counsels, we are able to provide hybrid or in-person court session observations to know how ICC scrutinized award is working in the community. So if you are only for the in-house counsel but not for the lawyers, so after the conflict check, so if you are interested, you are welcome to contact me or any of my colleagues to know better about the insider views. So I think if I may add one question to Mr. Wu, because we're talking a lot about the CPAC contract, everything. So we know how it works, the enforcement system works in Pakistan, but how it works in China, for instance, if there is a Pakistan-China dispute that from CPAC, for instance, and how it will be enforced in mainland China.
Yeah, so China is a signature country to the New York Convention. So foreign arbitration award, international arbitration award, will be, enforced in China. So even though I don't see many cases, in the past, but sure, I think recent years more and more cases has been, more and more international arbitration award has been enforced in China, and Chinese government and Chinese court is serious about that. But the procedure could be done because I remember in order for the enforcement. So just one point, you can see how serious the Chinese court system is about enforcement of arbitration, international arbitration award. So if any court decide to refuse to enforce the international arbitration, the review board will be a board at the Supreme Court, right? The People's Supreme Court. So yeah, I can see. We do expect more and more international arbitration award will be seeking to be enforced in China. But and I do believe the Chinese government, Chinese court system, will be more helpful and conducive to enforce the international arbitration award. Yes.
And thank you. And also, we talk about the enforceability of the ICC arbitration award. Now, I'd like to focus on the themes of the title of my panel, which is the fairness and efficiency of the ICC arbitration in resolving the disputes. So I think which is also another factors that the parties to the disputes really care about when they include arbitration clauses in their contract. So Manaz, and how to measure the characteristics of the fairness and the efficiency when you drafting the arbitration clauses or representing your case, and even like being arbitrators, that when you present how you measure those characters when your decision-making process.
Thank you so much for that question. I just wanted to put an overriding principle. Of course, it's the tribunal's duty to render an enforceable arbitration award. And that is precisely why parties enter into an arbitration proceeding in the first place. It's not just fun and games for the lawyers. The parties want an enforceable award at the end of it. And I think serving as arbitrator, I'm extremely mindful that it's not just the substance of the final award, but also the process that leads to the award. So by the time you've delivered an award, if certain procedural safeguards have been missed along the way, then it's a little too late. And I think when you are dealing with cross-border sort of arbitrations, it's very important to remember that it's not just the seat of the arbitration, but also where the arbitration award might be enforced. So perhaps the best way to illustrate it is a case that I was serving as on an arbitral panel. It was an institution that didn't have that much experience with the respondent's home jurisdiction. And we had a non-participating respondent. And under this institution's rules, email service was perfectly normal. And, but given the fact that I knew the jurisdiction, I realized that we had to make sure that the respondent was served by courier copies, in multiple, preferably with proofs provided to the arbitral tribunal at every stage, because it was so important that the respondent couldn't turn up resisting the arbitration award we had delivered, saying, I never received that email, and in any event, in my courts, service by email is not recognized. So, answering your question, I gave a very small example, but it's these small little things sometimes where procedural fairness is concerned that you often trip. So, it's very important for the tribunal to safeguard procedural and substantive rules throughout the procedure, right from the time of appointment, not just at the time of the award.
Thank you, Manus. And you talk about more on the fairness. So let's turn to the efficiency in particular. I would like to invite Sharis. So you know that in 2017, so ICC announced the expedited procedure to ensure that the efficiency of the entire process. So could you share some experience about how you see the efficiency, the importance of efficiency in the arbitration? Because actually some of the mega projects, as you mentioned, would be really time consuming for the parties. So how do you see that the importance of this efficiency and how ICC can achieve that goal?
Well, I think the efficiency part is like it's cost efficiency and it's time efficiency. When we talk about the cost efficiency, we need to see, like, I don't see it pragmatic that going all the way from Pakistan to LCIA in London is cost efficient in any way. And then maybe at that point of time when we were signing off those power contracts, LCIA was the most appropriate or maybe the only forum that was famous or popularly available in the world. So we had no other option than to opt LCIA at that time. But at this point of time, when we have a number of other places, for example, Abu Dhabi, ICC in Abu Dhabi, SCIA in Singapore, Qatar, QIC, DRC, we have got DIAC in Dubai. We have a number of other places now which are equally efficient in terms of time. Then the question of cost comes in, which is more appropriate for us. So well, I as a practitioner, I used to think, do we have direct flights to those places? Can we have access to those places in terms of if I have to go to Singapore, how much time do I need to have in order to secure the visa? Whether they are going to give me the visa in time, if I'm a Pakistani national, if I've got a Pakistani passport. So in those terms, I think that is one of the most important driving force that makes us think, if you are thinking pragmatically in terms of the efficiency of cost. So that the very first element that I need to consider, that which is the most cost efficient place. Of course, in terms of time efficiency, as you just mentioned, we have got expedited rules by the ICC. And if you have got certain claim, I think it's $3 million and below, you can opt for the expedited rules. In case you have, you can have the award within 180 days or so, which is fine. But it's not just this expedited rules which are going to impact on all of this decision making. Expedited rules are also getting famous in other arbitration centers, but I think it's the location, it's the seat. Which is why I think ICC also comes in, because they're centered in Abu Dhabi, and then we have got direct flights from Lahore, Karachi, and Islamabad almost every single day that goes to Abu Dhabi. So in that regard, we need to learn and we need to understand what will be the cost consequences when we are going to enter into that dispute. Going to England is one option. And then you also need to understand what type of legal system is working around there. You need to hire solicitors and then barristers, and then if you need to go to the court in terms of lex arbitri, what consequences are you going to have? But that's fine. As far as after the 2011 Act, in whatever jurisdiction you are, whether it's Abu Dhabi, it's London, it's anywhere else in the world, it will be considered and treated as a foreign arbitral award. And after the enactment of 2011 Act, as we are hearing since morning, like the pro-enforcement attitude, which is being now adopted and is clearly seen by the various judgments of the high courts and the Supreme Court of Pakistan, things are getting in a different clarity. So I don't think there is any enforcement issue, whether it's an ICC award or it's an LCIE award or it's an ad hoc award that had been, ad hoc arbitration award that has been issued in any jurisdiction, that will be treated and considered as a foreign arbitral award. And a judge of the high court is then deputed as the enforcing officer, who is now in line with the pro enforcement attitude. So enforcement is fine. So these ultimate elements of costs are very important. Cost is something which is an alien concept for the jurisdiction of Pakistan at the moment. We don't have cost consequences. We don't have cost follows the event, loser pays the winner. We are alien to these things. But when we go outside of Pakistan to other foreign jurisdictions, we undergo these heavy costs. I was given the stats that Pakistan alone has paid out almost $300 million in terms of costs only in last 5 years. So these are huge costs so these costs need to be considered, and I think this is one of the driving factors that will bring you along in making up the mind of which is the most appropriate place in terms of dispute resolution.
Yeah, thank you, Travis. I think you really point out one important point is the easy to reach for the institutions. So as you said, actually ICC has globally has 12 case management office located in all over the world, including Paris, including Abu Dhabi, including Hong Kong, Singapore, São Paulo, and New York. I think it's the still remain the only institution that you have the case management office worldwide, which you can always easy to reach. Actually, in our Dubai, Abu Dhabi office, we have also one colleague who is also Pakistanis who attended our conference, I think, last year. So I think this is really the important concept and information you shared to the parties. And actually, I think some statistics that from my end that we can share. And according to Mr. Wu, it seems like ICC has a long way to work with you. So I think that for ICC, actually 25% of our cases are involving infrastructure and power energy. So this is something, and also for the applicable law, I think in ICC arbitration, we do have Pakistan law to be applied in the disputes, and also other laws as well, including Chinese law, including Singapore law, Hong Kong law, etc. So I think this is maybe something that I'm happy to share with you. So I received the notes from our conference committee that we have only a limited time, but in the end that we would like to have to do two things and for our participants. So one thing is that we would like to see the future, because we also see the senior judge of the Supreme Court of Pakistan, Justice Zhang, also who I was really honored to be received the day before yesterday in Islamabad. So has also encouraged arbitration and mediation respectively. So which is I would see as a great encouragement for the global community to Pakistan. So may I invite Justice to share more like what we'll see about the future of arbitrations in Pakistan, also Mr. Sophie, about the ICC's future role in the arbitration sense of Pakistan.
I think that the framework that you're actually developing in terms of ICC arbitrations is important. I think the biggest issues that people in Pakistan or companies in Pakistan, I think it was earlier advocated in the construction zone as well, is that we have a take it or leave it option. And I think that's probably one of the biggest issues that ICC could possibly address in terms of bringing some parity. Because let's be very honest, some of these people don't want to dispute. They actually want to complete their obligations, but are being burdened with certain obligations at time which they feel they have no opportunity to do anything else but to accept. So in terms of the ICC, if that was something that could be addressed in terms of the bargaining power, in terms of contracts, that might be something that needs to be looked at.
Thank you. Well, I would like to first of all appreciate the Mediation Association, Kashif Saab. Whatever the work that you are doing is absolutely incredible, and it should develop into a momentum, frankly. And you need to dovetail with the honorable judges of the courts who are inclined towards mediation, and a lot of work is going on in Karachi and elsewhere. But I think one would like to mention Justice Jawad's outstanding work in terms of pushing parties towards mediation in various matters that has been brought before him, even winding up matters relating to companies, he has been Justice Mia Gul Aurangzeb and others. So there's a very strong sense in Islamabad judicial circles that there should be an inclination towards informal mediations. And we have seen this becoming gradually a success story in more than one cases. Even Justice Mansoor's one view that you should have mediation between the government and a private entity as well is an amazing area. So I think we can learn lessons from international conciliation mediation rules framework and build it as a social momentum. Thank you.
Thank you, Mr. Sophie. And this is really an exciting moment. And I also noticed that the Arbitration Act is being amended very quickly. So I think this is really also opportunities for Pakistan practitioners. So could you also give me some advices to the Pakistan practitioners in general for in arbitration service?
For Pakistani practitioners, I think it is the time. When I started my practice, there was a new terminology coined in the Pakistani legal market, which was corporate law. It was an alien thing in late 90s or early 2000s. So people who try to pose or to try to tell the market that they are corporate lawyers, they actually made quite a big lot of money as compared to the lawyers who were into litigation. Like we were running around in the civil courts and the district courts, and the corporate lawyers who were connected with the banks and doing those deeds and assignments, and they were making maybe 10 times more money than what the normal ordinary lawyer was doing. This is way back in 2001, 2, 3, 4, maybe 5. But now I think this is the Pakistani market is about to shift its tide. Like, imagine if we are going to have a new arbitration act which is based on model law, which actually emphasize that there should not be a court interventionist approach, rather than the approach should be the supervisory role of the court should be there. And imagine if we have a pre-action protocol mandating parties, just like we have got ADR acts, that you need to do some form of ADR, any appropriate method you think appropriate, then a lot of cases will then automatically start referring to the arbitration if it becomes actually in terms the most effective and efficient way that it poses to be in as the model law says. So I think this is the time when we have to now try to become an arbitration lawyer or an arbitrator itself. If we need to have arbitrations, like cases coming down for arbitrators, we don't have trained arbitrators. As the chair of the Chartered Institute of Arbitrators, it's been 2 years that we incorporated the branch in 2022, but then our classical dispute appointment service, we were unable to launch that in the market because we never had those trained arbitrators with us who can actually say that they are qualified enough to produce an enforceable award as compared to the TCC Court of England or the international standards. So we started training people. We trained 50 people in just 1 year. We want more people, but it's like a few hundred people as compared to 2.2 million backlog of cases. So for young practitioners, I think this is the time. This is the time to become the old corporate lawyer. The new corporate world will be an arbitration lawyer, I believe.
Yeah, I think this is exactly the exciting time, and also for the ICC to come to Pakistan, closer with Pakistan. I think that is also we need the practitioners like you and our distinguished panelists and also the participants. So last but not least, from our international perspectives, just a really quick tips to our community here. So could you also Manas and also Mr. Wu, could you share like 1 or 2 tips to our practitioners, so how they manage international arbitration, how they do this business, how they improve these systems? Please, Manas.
I think my tip is going to be very practical, and I think it's the full life cycle of the arbitration process. So when you're negotiating your contracts, to understand and anticipate a dispute might be in the offing. I mean, as a disputes lawyer, I tend to be fairly pessimistic because I see things falling apart all the time. But transactional lawyers tend to be more optimistic. So when they actually are negotiating the contract, particularly the arbitration provisions, it's very important to be mindful that there might be a dispute later on. And if you're agreeing a seat or a law later on, then you must understand the obligations of that law. And English law, if you are going to choose it, it's very important to make sure that you get English counsel's advice on enforceability, because English law has changed tremendously over the years. So that's my first tip. The second big tip is try not to breach the contract. I know it sounds like a very silly thing to say, but please, if you are taking on obligations, be aware that those obligations will eventually be before a tribunal or a court, and therefore you should do whatever you can to A, make sure that you're not doing anything wrong, and behave in a manner that's appropriately, because the correspondence that you write today will be before a judge later on, and they won't be very happy with what you say if it is not appropriately worded. And finally, if you're using AI, please be very careful. It is not a defense to say, I didn't write that email, Claude GBT did it. Right? So it's very, very important when you're not speaking English as a native language and you are relying on technology, because each comma, each word matters in an international arbitration. I hope that's helpful.
Thank you so much. Yeah, it seems like we open another panel on the AI. So, Mr. Wu, just the one tip for the participants.
Yeah, my tip will be beware of that. I mean, Chinese business and Pakistan business are different. I mean, they might have different business logic. They may have different business decision-making process. So please beware of that. Be prepared and be patient.
Thank you. Be prepared. And I think also our participants will be prepared for our lunch first. So first of all, I think we want to thank the organizer again and also my distinguished panelists. So last year, ICC Court celebrated 500 years anniversary. So our centenary was held last year. So this is also the first year of our new centenary in the coming century. So we are really looking forward to invest more, to be closer with our Pakistan practitioners, Pakistan parties, and also be with our ICC National Committee, ICC Pakistan, closer and deeper. So I wish you really enjoyed our panel, and thank you very much. Thank you.